Okay, hello and welcome everyone. Good morning, good afternoon, or good evening, depending on where in the world you are at this moment. Welcome to panel 5B of the ASYFAIR conference entitled Effects on Refugee Status Determination and Asylum Adjudication. My name is Rebecca Hamlin. I'm Associate Professor of Political Science and Legal Studies at the University of Massachusetts, Amherst. And I'm here in Massachusetts where it's very, very hot. And I'm very excited to be chairing this panel today. This is a topic that's near and dear to my heart. It's something that I've been thinking about and studying for almost 20 years now. On this panel, we have three exciting presentations that are all looking at refugee status determination, or RSD, in different national contexts. Hopefully at the end of these three presentations, we will be able to have a very interesting conversation about which elements of RSD are universal and which are very particular to the national context of the potential host country where they take place. So our first presentation for you today is by Yukari Ando from Osaka University. The title of her presentation is Asylum Law Decision-Making and Adjudication in Europe and Japan. So I will now turn it over to Yukari, who I believe has a PowerPoint presentation.
Thank you, Rebecca. I'm going to share my presentation PowerPoint. Can you see that? Okay, good. Okay, so I would like to talk about asylum law decision making and adjudication to compare between Europe and Japan. And that's in today's agenda. I would like to focus the 3 points. One is the decision making process in Japan, and immigration bill recently proposed by the government and already withdrew the bill. So I would like to talk about the content of the immigration bill. And also, now we are facing the Tokyo Olympic 2020, well, actually 2021. And in the name of the Tokyo Olympic, the government of Japan is declared the peace and safety, but it's really concerned about immigration. So I would like to focus for 3 points. So first of all, the decision-making process in Japan. Before going to the decision-making process, I would like to show you the statistics of the refugee application. So since 2011 until 2020, we have the significant number of the refugee claimants. Of course, to compare the European countries and the United States, the number is quite small. But even though the 2017, we had 20,000, and last year about 4,000. And how many people are recognized as a refugee is very small. The convention refugee, which is recognized as refugee convention, is 47 out of about 4,000. And special permission to stay, which is non-convention refugee, but the humanitarian status is 44. The total is 91 last year out of 4,000, which is quite strictly very small number of the protection of refugee and humanitarian protection. So that is the first emphasize how many people are protected in Japan last year. And from where they are coming to Japan, the highest is Turkey, and second largest is Myanmar and Nepal. But please look at who are recognized as refugees last year. None of Turkish and none of Burmese are recognized last year. So that's the reality in Japan. And maybe you can imagine how strict to determine in refugee in Japan. And I would like to explain about refugee status determination process in Japan. So there are three stages. The first stage and second stage is an administrative procedure, which is examined by Refugee Determination Officer, which is staff member of Ministry of Justice. And if the refugee claimant fails, they can go to the second stage, which is examined by Refugee Adjudicator, which is who is external person. And first, second is administrative procedure. If the person is exhausted administrative procedure, they can challenge before the judicial review. So judicial review, of course, examined by judges. And in Japan, the judicial review has three stages. Like the first of all is the regional court and high court, and finally Supreme Court. So that is RSD in Japan. And I would like to focus on the second stage by Refugee Adjudicator. So Refugee Adjudicator is not staff member of the public official. They are exercised by individual capacity. And now, as of 30 June 2021, we have 155 adjudicators, and their former work experience is ex-judge and ex-prosecutor, and the current attorney at law, and ex-diplomat, and current scholar, and also ex-scholar, and others. And others are included the NGO, NPO, and other experience. So in total, 155 adjudicators are exercised for the second stage. And refugee adjudicators are appointed by the Minister of Justice. And under the Immigration Act, refugee adjudicators are persons of reputable character who are capable of making a fair judgment on the appeal and who have an academic background in law or international affairs. That is why ex-judge, ex-prosecutor, and lawyer, and scholar in international law and in law, and ex-diplomat appointed by by the Ministry of Justice. And the refugee adjudicators consist of the panel, and 3 refugee adjudicators decide whether the person is qualified of conventional refugee or not. And now there are 3 branches of the Immigration Bureau: Tokyo, Nagoya, and Osaka. And Tokyo is the capital. And of course, the Tokyo has a lot of cases. And Nagoya also has a lot of cases. And Osaka, where I am, is not really many cases. Why? Because Tokyo is the capital. A lot of people go to the apply refugee status in Tokyo. And why Nagoya? because Nagoya has a headquarters of Toyota. And Toyota is a really big company, and a lot of people are looking for the job. Therefore, Nagoya Regional Immigration Bureau has quite many cases dealing with asylum cases. But Osaka is relatively big, but unfortunately, Osaka is not really dealing with many cases for refugees. And Japanese characteristics of the adjudicator or refugee status determination. We do not have refugee tribunal, and we do not have immigration tribunal either, and we do not have human rights tribunal or human rights commission. But we do have Immigration Bureau, Ministry of Justice, but their money is mostly inspector, immigration inspector, not really immigration protection, but inspector. And refugee adjudicator, we have 115, but most of them are not really familiar with refugee law. And administrative case dealing with section of civil department of the court, but most of the cases of administrative case is not only immigration case, but environment case, anything against the government. So judges under the administrative case are not really familiar with immigration case. That is really Japanese characteristic. And those three profession training seem insufficient. They are not really trained by the specific psychological asylum seeker. So that is what I would like to really emphasize Japanese situation. And I would like to move to the immigration bill. So as I told you before, 18th of February this year, the government leading party proposed the immigration bill. However, many protests happened by attorney at law, by scholar, by civil society. And finally, 18th of May this year, the leading party decided to withdraw the bill. So now we do not have to worry about proposed bill, but I would like to tell what the most concern about proposed immigration bill this year. So concern from experts, at least we did have the joint statement on special rapporteur on the human rights of migrants, working group of arbitrary detention, special rapporteur on freedom of religion or belief, and special rapporteur on torture and other cruel, inhuman, or degrading treatment or punishment. So they created the joint statement to concern about immigration bill. And you can go to the detail about their statement. And also UNHCR comments on amendment of the bill. So UNHCR concerns are very long and very detailed. But I would like to focus two things concerns about the immigration bill. One is a violation of the principle of non-refoulement. Of course, the Refugee Convention, Article 33, and also misuse of complementary protection. So the government proposed the notion of the complementary protection. However, as UNHCR stated, the criteria for complementary protection, the proposed wording does not reflect that used under international and regional refugee human rights law. And I fully agree about the UNHCR statement. Why? Because complementary protection under the international human rights law, like ICCPR or Convention Against Torture, they do not require the persecution. Because of the complementary protection is to protect from irreparable serious harm if they are deported. So, of course, under the Refugee Convention, persecution is an element, but under the complementary protection, persecution is not element at all. But the proposed bill is required. The persecution is necessary under the complementary protection, which is totally different norm of the complementary protection of the international standard. And if we look at the qualification directive of the EU, Article 15C, it says indiscriminate violence. If somebody is indiscriminate violence, individual element is not necessary at all. But the proposed bill requires individual elements, so that is totally a different norm from the international standard. But that is one of the most challenges of RSD in Japan. Interpretation of being persecuted in Japan is very important single out, which is individual elements are necessary, which is totally different from international standards. And the burden of proof is too much for the applicant. And the benefit of doubt is not recognized in Japan. So that is very challenging in Japan. And I would like to move with the peace and safety for international standards. As I told you, peace and safety for Tokyo Olympic is very important for the government of Japan. And June 9th of this year, the National Police Agency, Ministry of Justice, Immigration and Refugee Recognition Agency, together with Ministry of Health, Labor and Welfare, stated promotion of measures against illegal employment of foreign nationals. And we still use illegal migrant and illegal alien. And recently, the United States abolished to use the term illegal alien because illegal might confuse and make different idea. So instead of illegal, the United States clear stated to use undocumented or irregular. And many European states already use undocumented or irregular, not using the illegal, but we still use the illegal in Japan. And the government of Japan is aiming to create Japan the safest country in the world. I agree if we can create the safest country, but safest means is not that the government says. What is peace and safety? Peace and safety means effective protection of human rights. Under the Constitution of Japan, as well as international human rights conventions such as ICCPR, all human beings are born free and equal in dignity and rights. So that is very important to look at safety and peace. So we do not use illegal alien. So we need to use irregular migrants instead, for example. So that is really negative things I'm telling you, but I can finish. Before I finish, I would like to tell some positive development for particular social group interpretation in Japan. So last year, 2020, under the particular social group related to the gender discrimination, the Japan accepted 4 cases under the Refugee Convention. One is a homosexual case, and actually homosexual case was really difficult to be recognized as refugee in Japan. But last year, at least one case about homosexual case, and also the circumcised FGM case, and post-married case, and also lesbian case. So at least 4 cases are recognized last year, which is quite significant development of RSD in Japan. So I would like to finish my presentation. If you have any questions, thank you very much.
Thank you very much for that very interesting presentation about Japan. I'm sure there are a lot of questions, and I think we're going to go through the 3 presentations and then try to have a question and answer period regarding all 3 papers. And so the next presentation we're going to hear is from 3 presenters: Francesca Di Blasi, who's a legal officer from social, oh, that's your timer, so you did perfectly. Daniela Peruso, a PhD candidate at University of Essex in the UK. Cristina Russo, an intercultural trainer and mediator from the Fondazione Intercamini from Italy. And the title of this presentation is The Italian Reform of the Judicial System in the Asylum Procedure, Speeding Up the Application Process or Weakening Refugee Rights to Defense.
Hello, everybody. My name is Daniela Peruzzo, and with my colleagues Cristiana Russo and Francesca Di Blasi, we will speak today of the Italian reform of the judicial system in the asylum procedure in Italy. The topic of this presentation will be focusing on the role of the Court of Law in the refugee status determination process in Italy. And we will be discussing in particular 2 points: the innovation introduced by Minitis Act, partially entered into force on the 17th August 2017, and their effects on the judicial system in relation to asylum. We will focus on 2 innovations introduced by Minitis Act in particular. The first is that while the Italian judicial system provides for 3 stages of proceedings, the Minitis Act abrogated the 2nd instance of judgment in relation to the asylum process. In so doing, it creates a discrimination between Italian and third country nationals. Furthermore, the new decree replaces the claimant's hearing with a video recording of the interview held at the territorial commissions. The territorial commission is in Italy the administrative board that interviews an seeker and decides about their claims. And the judge is expected to watch this video recording to make his decision instead of listening the asylum seekers during a hearing as it happened before. Our thesis is that the act weakened the balancing role which before it the courts exerted in relation to the territorial commissions, affecting in this way the fairness of the appeals and refugee rights to defense. In the light of the subsequent Salvini reform, furthermore, which abolished the humanitarian protection, the decree also appears to be a piece of a wider political strategy designed to empty the rights provided by the 1961 Refugee Convention. In fact, while a new decree, the Lamorgese decree, introduced later a similar protection to the previous humanitarian one, there are not enough data to draw conclusion on its effects on the applicant's access to a formal status. In this presentation will be structured as follows. I will briefly touch the main problems which beset the Italian refugee status determination process before the Menisi Act, problems that we think that the court could counterbalance. Then Francesca Di Blasi will mention some positive improvements of the Act, and we will discuss the issues which I just mentioned. And Cristiana Russo finally will draw our conclusions and recommendations. It should be noted that the attempt to create a common asylum system for all member states of the European Union have been going hand in hand with the adoption of increasingly severe containment policies aimed at limiting the arrival of asylum seekers in Europe. And in this context of growing restrictive immigration asylum policies, NGO and advocacy workers denounce the spread of an ever-increasing cultural disbelief of applicants' clients. In regard to the cultural disbelief, there's an interesting research carried out by Anderson, Olas, Lisney, and Williamson, who focus on how, to what extent the cultural disbelief manifests through the performance of law. This research was based on ethnographic participant observation of the court hearings and is based on an interpretativist ontological epistemological paradigm. In this perspective, the courtroom is considered as a site of cultural production. And according to this research, the culture of disbelief is conceptualized not as a pre-existing entity, but as something that manifests when, if certain elements combine to reduce the space for the examination of a crime. And among these factors that can reduce the space for the examination of application, there are, for example, issues surrounding linguistic and cultural translation, but also the narrowness of cultural repertories of judge, of the hobo and the solicitors. So the testimonies, the narratives of appellants can be distorted and misinterpreted just because of the poor knowledge of the social political context of the countries of origin from the officials and the judge. And we believe that these elements were present also in Italy, in particular a report edited by Senza Confine Onlus, NGO in Rome, a report called Suspended Voices, have found out this element as recurrent in the Territorial Commission of Rome. Lack of trained interpreters, official inadequate understanding of countries of origin, institutional, juridical, and socio-cultural figures, lack of pertinent up-to-date country of origin information. It also, they found out that commissioners lack of specific training, and this was an open violation of the provision of European legislation on asylum. The report, furthermore, cast doubts on the independence of the territorial commissions. The independence of the territorial commission was put in discussion because of their composition. Territorial commission before Menedict's Act were formed by a president, a public servant with previous experience in public administration, national security, whose vote when deciding on granting of status counts double, a law enforcement agent from the state police, a representative from a local authority, a representative from the refugee agency, and the members were nominated on proposal of the Minister of Interior and validated by a decree from the President of the Council of Ministers. And this designation process, as it easily can be understood, can affect the territorial commission effective independence, because it makes an administrative office a direct emanation of a governmental body with immense implication for the protection of people of concern. Now, Francesca Di Blasi will talk about the positive innovation introduced by the Minitis Act.
Okay. According to Minitis Act, we can see different issues that brought positive innovation. For example, are welcomed this specialized section of courts in the matter of asylum, and is also welcomed the professionalization of the judges. Acknowledging the high level of expertise needed to deal with the international protection, the Minitis Act decide to specialize this section of court, and also decides that the magistrates who will be assigned to the court should have worked on the matter for at least 2 years or have attended training courses on the subjects organized by the European Asylum Support Office and the United Nations High Commissioners for Refugees. In order to enhance judges' competencies, specific training sessions are dedicated to interviewing techniques, such as, for example, dialogical communication method, considered by the European Asylum Support Office the most valid one to interview asylum seekers. Also, the knowledge of English is positively considered when assigning magistrates to the specialized sections. Lastly, to compensate the elimination of the second instance of judgment, the new decree introduced the obligation for judges to make decisions collegially instead of individually, as they used to do previously. Okay, as Daniela told before, the Court of Appeal was abrogated by this act, and from a legal perspective, while the Italian legal system provides 3 levels of judgment, even in civil cases, just a first instance on the matter is available to determine whether a foreign national will face persecution or torture. As noted by the National Association of Magistrates and by ASGI, the abrogation of the second instance just for refugees not only reduced asylum seekers' guarantees, but established a severe discrimination between Italian and third national citizens. Another negative consequence is that it makes many courts do not suspend the expulsion, and this creates inequality in the access to a fair defense to refugees. It also puts refugees with an expulsion who remain in Italy with a very low level of access to training and a regular job in an illegal status with a high risk to be enacted by a criminal organization. And it also makes asylum system really hard to navigate even for expert lawyers. Now we will see the introduction of the video recording and the deletion of the mandatory hearing. The video recording in itself seems a positive innovation. It can help to overcome recriminations and misunderstandings between interpreters, applicant, and interviewer. However, its use as the principal piece of evidence causes concern. The applicant is not given a copy of the video recording, which will be available only in the context of the judicial appeal, while it would be useful to have it. And the hearing can still be scheduled in some strictly coded circumstances, and the decision on whether an hearing will take place is taken only by the judge. So we have a very hard limitation of the adversarial principle and a flagrant violation of the right to a fair and public trial that we find in Article 111 of the Italian Constitution and Article number 6 of the European Conventions on Human Rights. And also, we have a violation of the right of defense that we can find in the Article 24 of our Constitution. Now, our colleague Cristiana Russo will take us to the final conclusions of our presentation.
Minniti and Salvini Acts appears to be a piece of wider political strategy designed to empty the rights provided by the 1951 Refugee Convention. In fact, they have weakened the refugee protection by limiting refugees' rights to defense, weakening the balancing role of courts exerted in relation to the territorial commissions for asylum, limiting the court's influence on the asylum procedures. The reform has given impulse to the specialization and the professionalization of magistrates and courts, but has limited the court's influence on the asylum procedures. The introduction of the judge's collegial decision do not compensate the abrogation of the Court of Appeal in terms of guarantee of a fair trial. The weakening of refugees' protection has two consequences. In the context of a constant increase in negative decisions of territorial commissions for asylum, as it is indicated in red in the table, the abolition of humanitarian protection, which was granted by tribunal to safeguard those applicants who were not eligible for refugee status but still in need of protection, will further increase the number of appeals against the territorial commission's decision, and then the court's work, in open contrast with the manifest goal of the Minniti's Act of speeding up the asylum procedures. 94% is the average rate of appeals against the territorial commission's decision at national level between 2016 and 2020 first semester. The second consequence of the weakening of the refugees' right to defend is the increase in refugees' vulnerability and marginalization. More than 157,000 of asylum seekers whom international protection claims were examined in Italy between 2016 and the first semester of 2020 are at risk of remaining in country without a permit of stay. They are therefore forced to live in a vulnerability and precariousness. Precarious living conditions make asylum seekers become targets of the xenophobic propaganda. In order to grant the right to defense, three kinds of actions have to be taken. First, to monitor the impact on the fairness of the refugee status determination process of the video recording on interviews in the appeal process, once it will be effective. Second, from a legal perspective, it urges to reintroduce the appeal as an equal opportunity and anti-discrimination provision. Third, it calls to monitor the decisions of the territorial commissions on recognizing the new special protection introduced by the Lamborghese Act in all cases where individuals are not eligible for international protection. Thank you for your attention.
Thank you very much for that interesting presentation about Italy. And we're going to continue our world tour now and move on to our third presentation. This presentation is by Maxime Maréchal, a PhD candidate at the Université de Paris in France. And its title is An Existing Role and Emerging Function, the Complex Process and Consequences of Interpreters' Professionalization at the French National Court of Asylum. Go ahead, Maxime.
Thank you very much. Thank you for the introduction. And I'd like to start with a very interesting quote for my subject of research, a quote that talks about the intellectual performance of claiming asylum. It goes, to say the misfortunes of one's life and to make them sayable, then in the same effort to make them audible to the judges and incidentally to the lawyer, according to their own representations of the world, without ever deviating from the imperatives written in the 1951 Geneva Convention, represents the whole intellectual performance that the asylum seeker must achieve. If this operation is poorly performed, if the words are ineffective and the speech incoherent, then the construction of the meaning of the claim will miss the institution, and thereby the very narration of the experience of persecution will become meaningless. So it's a quote from Smaïn Lacher, and it's interesting to know the author because he's both sociologist and as an assessor judge at the National Court of Asylum in France. So he's talking as a judge and a sociologist at the same time. It's also interesting because I think it gives a sharp description of the strategic importance of discursive performance in the asylum adjudication system within this paradigm that was mentioned of credibility that shapes the whole administration. And the most important and interesting thing I think about this quote is that it talks about making sayable, making audible representations of the world, speech, words, and it doesn't even mention the interpreter. So I think this is a really troubling fact because it's not mentioning it nor before nor after, it's just not present, the interpreter. So I think it's something we have to flag because even if this quote is not does not represent the whole institution or every judge's opinion about interpreting, it still underlines something like a gray zone within the institution about interpreting. And I'd like also to remind that in France, interpreters in asylum administration are compulsorily professional, but also external, meaning they're not public servants. They are employed by external service providers. So there is quite an apparent paradox in reality in forgetting the interpreter, as this quote just did, because interpreting has a really quantitative importance in France as and elsewhere. But as in France at the French National Court, a majority of the hearings are held with an interpreter, which represents a great organizational and financial stake, because in 2018 it was about 3 million euros for the interpreting budget. it is also a form of interpreting that is very, very the object of many norms, much more than other forms of public service interpreting, as interpreting is present in the procedure directive of the Common European Asylum System and in the national law. It is also normated by the institutions themselves and also by interpreting service providers. And finally, interpreting is broadly recognized as something important and something central, as it is now very clear for most of scholarship on this subject that it is an activity and not just a mechanic device. So it represents a real activity where the interpreter has agency. And if it was at the beginning in the 1980s studied by only legal scholars, it has become a field, an entire field in the interpreting studies now. So knowing that, I'd like to think of the way of understanding the interpreter's function. And first I have to say a few words about the asylum procedure in France, which is centralized and where people first go to OFPRA, Office Français de Protection des Réfugiés et Apatrides, which is a government department. And this is the place where the first interview is made. And afterwards, if the decision from OFPRA is negative, asylum seekers can go to the Cour nationale du droit d'asile, which I will call CNDA, so the French Court of Appeal, which is an administrative court involving public authority, here OFPRA, and it is a full jurisdiction, meaning it can grant protection if it annuls OFPRA's decision. And there are hearings either with a panel of 3 judges or, and it is getting more frequent, only 1 judge. Also, I'd like to talk about the way that interpreting in asylum context has been dealt with in interpreting studies. Because since these very early times I was talking about in the 1980s, where it was only studied in legal perspective, now it is very much field-based, and there are almost always ethnography and conversation analysis data, which show many complexity of the interpreter's position in the interaction, which I cannot develop here because I'd like to move on. But for instance, a very recent article, which is here at the very end of the slide, showed how the interpreter is central in the management of turn-taking between the actors of the interaction. On the other hand, sociological approaches to interpreting in asylum contexts also exist, and they deal with the relation between the interpreter and the institution. Here again, I'm not going to go into details, but just to mention them, especially the works dedicated to the interpreters at the French CNDA, because of course they are very important and too rare for the moment. But knowing that, I think still, as I was talking about a gray zone within the institution, maybe there is a gray zone within the literature also, because on the one hand, for interpreting studies, there is a general lack of contextualization of interpreting phenomenon, as almost always the interpreter is considered as an actor. So there is the interpreter, the judge, and the appellant. And it enables to study a lot of interactions, of course, but it also blurs the social and political and personal individual background of the interpreters, which is a shame. because in sociological research, which is of course more in this perspective, I think interpreting is not really always tackled with linguistic and interpreting studies tools. So he or she becomes almost an actor as the others, while she has or he has specific tools. That's why I will give you a few insights from my doctoral research, which is a work in progress, about the way I try to approach the interpreter's function at the CNDA, knowing all that. Because I think that it's clear the interpreter has an interactional role. It's quite broadly recognized, but there is and there are processes of professionalization within the institution that finally lead us to wonder if an emerging function is not arriving, meaning maybe we are witnessing the passage from an interactional role towards an institutional function, a complex and ambiguous one, of course, because as I said, the interpreter is always external to the institution, but that's the way I think we can understand the specific way interpreters act within the CNDA. That's why I try to create a social history of interpreting in the CNDA. And I tried to link three main things. So first, asylum policies and their evolutions at the European level. So with the Common European Asylum System I mentioned, and which I will not develop here. And also the way that categories like refugees or asylum seekers or economic migrants are constructed. To link that with the evolutions of the institution itself, as the CNDA has seen a great professionalizations of its actors, and not only interpreters, also judges who have become more professionalized than they used to be. As CNDA has become the first administrative court in France, according to the number of cases they deal with every year. And I think it should be linked also to the evolutions of public service interpreting sector, which is not very much studied, because there we can see that asylum administration has become vital economically for those actors, because we just saw that there are many new cases, and so an increasing activity. It has become a highly competitive field, and it has this has created an asymmetrical power relation between the institutions, here the CNDA, and interpreting services providers, which of course influence the everyday work of interpreters within the institutions. I wanted to talk to you about the way that interpreting has been institutionalized, but I think I'm gonna be quicker on this because I'd like to talk about some other things. But it was just to mention that in 1993, dedicated service department for interpreting was not made because of financial motives. And 2 years ago, the CNDA decided to individuate from the formerly common interpreting market with of PRA, meaning that they now want to have their own independency on the matter. So it has become something also very more specific. So to finish with, I'd like to give a few ethnographic insights of the interpreter's function within the CNDA. Insights highlighted by the socio-historical facts I try to hint at. So the very striking thing is the way operational concerns are really present, be it during the interview or on the field, because interpreters have a lot of time and space constraints. For instance, if they are even 1 or 2 minutes late, the CNDA will make pay financial penalties to the structure that employ the interpreters. So they are really, it's really stressful because yesterday Nick Gill said that the situation of interpreters was different from one country to another, and it's very true. But he also said that it's a tough job everywhere, and that's indeed a tough job because interpreters are controlled by security staff at the entrance of the CNDA, for example, and they should have special badges, but due to administrative problems, many of them don't. So they are many of them say that security personnel think they are themselves asylum seekers. So it's very stressful when every minute can be crucial. And there are also space constraints that I'm not going to develop here, but it pictures the way that interpreting service providers are really dependent financially. And many interpreters feel that they are at disposal of the CNDA, and sometimes they are told they are at disposal by secretaries, for example, who try to organize the hearings and say, no, you cannot leave at this time because we need you. You are at disposal for the purpose of the court. So it's a very hard situation because, as I was saying, there is this being late problem, but also there is the fact that they work extra hours very, very often, and those are not more paid. So it's like there are the two sides of the thing. So they feel they are at disposal, whereas at the same time, formally they should be neutral and external and independent. So I think this financial dependence is something interesting to analyze, to understand how they work and in which conditions they can, well, manage to interpret as they should. I'd like to give a last example that really questions the function of the interpreters at the CNDA. It's the case of English, so interpreters who work in French and English, because English seems to be a common language, and especially for judges who have academic trajectories. They think they understand and they can speak English, which is true, but forgetting that they speak a certain variety of English. And many appellants, for example, from Nigeria, speak another variety of English, which can be really misleading because even the vocabulary itself is different and can be very confusing. But at the same time, the interpreter will always be here in English because it is legally compulsory. So it's only if the appellant wants to speak in French that there is no interpreter, but in English there will be one, even if the judges consider that it's not needed. And sometimes even the interpreter considers it's not needed. So it creates situations where the interpreter is really in danger as far as his or her legitimacy is concerned. And that's the case, the example I wanted to highlight, because I think it shows how we can contextualize issues that have been dealt with by interpreting studies. For example, the concept of face, which is used to understand the interactions. But I think contextualizing the interpreting work enables us to see this question of face, the way the interpreter and the other actors try to defend themselves and the legitimacy of their presence. I think this can really be it can be more how can I say, more clearer maybe, or at least closer to the field and the everyday work for interpreters there. So I hope I haven't gone out of time, and I thank you very much. Here are the references, and I thank you very much for your attention.
Thank you so much. 3 wonderful, richly detailed presentations giving us perspectives on RSD in 3 different national contexts, and they were all very well timed. So thank you, making my job quite easy. We're out of time, and I just want to thank all of you, our presenters and our audience members, our questioners. This has been very, very interesting, and I'm just really struck in this moment about how much we've learned today about these 3 wealthy democracies, which are walking quite a fine line, trying to design a system that gives the appearance of procedural fairness, administrative justice, but also isn't terribly generous, right? It seems like both of these goals are being built into these 3 systems, and they're in quite a bit of tension with one another. So it's interesting to see the 3 different manifestations of that tension in these national contexts. So thank you very much to everyone.